can recover consequential damages, that is, damages above what the policy expressly provides in a breach of contract action without having to file a bad faith case? We submit that the answer to that question has to be no. I think the court can analyze this from two different lines of cases that will get you to the same point. The first line is the Denny Associates QBE versus Chalfant line of cases, which hold that in interpreting an insurance policy, we don't look at the party's reasonable expectations. And that's because insurance policies, unlike other policies, do not require parole evidence to resolve ambiguities in the contract. If a contract is, an insurance contract is unambiguous, then like other contracts, you read it according to the express terms. If an insurance contract is ambiguous, you don't look at parole evidence, you interpret it in the light most favorable to the insured. And so Denny Associates actually answered the question of how do you interpret ambiguities in a CGL insurance policy? And the court said, according to the plain terms or interpreting it in favor of the insured. Therefore, the doctrine of reasonable expectations doesn't apply. The doctrine that the district court imposed and which Manor House wishes this court to adopt is that extra-contractual consequential damages are permissible if they were within the contemplation of the parties at the time of the contract. There is no difference, either practically, legally, or logically, between being in the contemplation of the parties and what the parties' reasonable expectations were. They're necessarily the same thing. You have to look at parole evidence either way. And so under the Chalfant, Denny Associates lines of cases, you can't get there. You can't consider what the parties contemplated, and therefore extra-contractual consequential damages are impermissible. The court can also come at it from another line of cases, which is the McCullough Talent Enterprises cases, also from the Florida Supreme Court, from this court. McCullough was in 2006, Talent was in 2000. And in those cases, the court decided that, or the court noted that under the common law, the only damages available to an insured for the breach of contract were the damages stated in the policy itself. In McCullough, the court said the only common law action available to the insured was a breach of contract action against the insurer in which damages were limited to those contemplated by the parties in the insurance policy. That's at page 455 and 56. And in Talent, the court said—
Counsel, can you distinguish the damages contemplated by the parties in this case from the damages contemplated by the parties in, for example, the Life Investors Insurance Company of America versus Johnson case, or any of the other cases where the insured's intended purpose of getting a policy to ensure that payments continue or that their economic interest is preserved is protected against, right? How is this case different?
Well, first, when you talk about the other cases, really there are no other Florida cases other than Life Investors versus Johnson that hold that in the first party context, you can have consequential damages. That's a 1982 case that was decided not under the contemporary scheme of the bad faith statute 624-155. That case did not distinguish between breaches of insurance contracts and breaches of other contracts. And this court has noted in Talent, and I believe in other cases, has noted the difference. Lafayette is the case I'm thinking about, has noted the distinction that the common law has made between interpreting insurance policies and interpreting other policies. And in fact, there are a lot of differences in insurance policies. And that's why this court has said that because of the unique institutional nature, the court said, of insurance policies, we have interpreted those policies differently. And just some of the differences are, for example, what I just said, you don't interpret insurance policies under parole evidence. If there's any ambiguity, the insurance company loses. That's different from the run-of-the-mill contract. Also, they can't have a prevailing party attorney's fees provision in these contracts. They can't even prevent the insured from getting attorney's fees because the statute 627.428, which Citizens is subject to, by the way, provides for attorney's fees to a prevailing insured in a breach of contract action, but not to a prevailing insurer. That's another distinction. In QBE versus Chalfant, this court made another distinction. There's no common law duty of good faith and fair dealing in an insurance contract because we have the statute 624-155, and at common law, there was no bad faith action in the first party context. There are other differences as well. The insurance contracts are highly regulated. They have to be approved, and even changes have to be approved by the Department of Insurance Regulation. Life investors distinguish none of these cases. It was decided under a prior scheme, even though it was 1982, the same year that 624-155 was enacted. It was looking at a bad faith statute scheme of things because the contract had been done before the bad faith statute. No Florida court since Life Investors versus Johnson has followed that case. That case is an outlier. And probably the reason that it doesn't matter to anybody anymore is because we have the bad faith statute. Because in every other case, except for a Citizens case, which is why we're here, an insured can file a bad faith action, can get attorney's fees, can get more damages than they would in a breach of contract action, can get consequential damages, and can even get punitive damages under certain circumstances. If you look at subsection 5, those circumstances have to be met, but it's possible to get punitive damages under the bad faith statute. None of that happens in your run-of-the-mill case. And that's why no case has followed Johnson in the 38 years since it was decided. Justice Munoz, did you have a question?
Yeah, I'm sorry to interrupt you. Did you have anything else you wanted to say in response to Justice Coriel?
No, except what I just said, no cases followed it. And the other cases you referred to, all those cases can be distinguished. For example, TDS, the 11th Circuit case, if you look at footnote 12 on TDS, they didn't decide the case on contractual consequential damages. They said, because we decide this on the fraud consequential damages, we need not determine whether consequential damages are available in a breach of contract action. And I can go on and distinguish the other cases that the 5th DCA cited. We've done that in our brief. Justice Munoz?
Which of the two paths that you outlined, which would be narrower in the sense of having fewer sort of broad insurance law consequences?
Well, Your Honor, I don't think any of them would have broad insurance law consequences because really all you're doing is keeping the status quo. There's nothing in there in those cases. For example, when Denny and Chalfant say that we don't have the doctrine of reasonable expectations, and that has been the law since Denny in 1998. So to say that here and to equate consequential damages that they contemplated at the time of the contract with reasonable expectations is not going out on a limb for this court.
Well, but in that case, I mean, obviously the case does have that line in there, but it wasn't something that seemed like there was a ton of analysis or thought that went into it. I mean, it's sort of, that one line kind of in the middle of the paragraph. And I'm not disputing you, but I mean, obviously it's enough. The 5th DCA, I mean, those are good judges. I mean, the concept, if it's that basic, I mean, it eluded them. And so I'm just curious, do you view the two paths as what would be the argument for choosing one path or another?
I don't think there is, because they're both based on two cases from this court. So they're both, equally based on precedent from this court that's established, not just in one case, but in more than one case. But the McCullough-Tallet Enterprise line of cases is just as legitimate. It's not going to present, any consequences in other cases. And that's the one that says that in the context of an insurance policy, the damages the insured gets is what's provided for in the insurance policy itself under the common law. You don't get extra contractual, you don't get consequential damages. So that line of cases is just as legitimate. But let me make one thing clear, Your Honor. I don't think that anything that you hold today is going to have a huge effect if you hold in our favor, because this has not been an issue for the last 38 years. Like I said, Johnson has not been followed by any other Florida court. And the reason is that insureds have the bad faith action to recover their consequential damages. We don't dispute the fact, and nobody has, that consequential damages are available under the bad faith statute. Even more are available, punitive damages are in certain circumstances. And that's why no insured cares about Johnson. No insured cares about consequential damages. They just file a bad faith lawsuit. The reason it's important in this case, frankly, is because you can't sue citizens for bad faith. This is the only way they could try to get consequential damages, by making it part of the breach of contract. So this court's determination, if you rule in our favor, practically speaking, will only affect citizens. But if you rule against us, it's going to affect citizens in a major way, because essentially you'll be giving insureds a backdoor mechanism to obtain bad faith damages without having to file a bad faith action. So it's even worse in a sense, because under the bad faith law, even if you file a third-party bad faith action under the common law, courts routinely either dismiss those pending the breach of contract action, or they abate those during the breach of contract action, because you're entitled to certain discovery from the insurer in a bad faith action that you're not entitled to in a breach of contract action. For example, the claim file, all the thoughts and insights of a claim adjuster during the claims process are available in a bad faith action. If you allow consequential damages, they're going to seek those kinds of damages in the breach of contract action itself. And so while a ruling in our favor is not going to do very much to insurance law in Florida, a ruling against us will have devastating consequences on citizens' property, which is designed to be the insurer of last resort and provide the only company that is required to try to provide affordable insurance to property owners in Florida. Unless you have any other questions, I'll reserve the rest of my time for rebuttal. Thank you. We ask you to quash and answer the certified question in the negative.
Counsel, you may proceed.
Thank you, Your Honor. May it please the court, Alex Brockmeyer on behalf of Manor House, Ocean View, and Merritt State. We're asking that this court answer the certified question in the affirmative and hold that consequential damages are an appropriate remedy in a first-party breach of contract case. Like my opponent said, in 1982, prior to the enactment of 624155, consequential damages were a remedy under the Johnson case in a first-party breach case. Where I disagree with my opponent is that subsequent to Johnson, courts have in Florida followed that line of reasoning. We see that in the 5th District's decision of Travelers versus Wells, where the court relied on the TDS versus Shelby case out of the 11th Circuit, which in footnote 11 of the opinion cited with approval Johnson versus Life Investors. And subsequent to that, our federal courts in Florida, which I recognized are not binding on this court, but we do submit they are persuasive, have followed that Life Investors versus Johnson line of reasoning to recognize that as a baseline rule, this remedy is available in a first-party breach case because at bottom, an insurance policy is a contract, like this court said in Lumbermans versus August. And contract law governs the parties' rights and obligations to that policy. And contract law provides for consequential damages as an available remedy in the event of a breach of contract. It's the rule that we all learned our first year in law school in contracts class with Hadley versus Baxtendale. And that's what the Life Investors versus Johnson case drew on when it held that as a baseline rule, this is an available remedy. Now, the enactment of 624155 does not materially change the availability of that remedy. Even my opponent noted that the Johnson case was decided prior to the statute's enactment, which is important because subsection 8 of 624155, in plain and unambiguous terms, the first sentence says, nothing about this statute will preempt any common law remedy that exists. And we can see, as my opponent conceded, Johnson recognized that consequential damages was a common law remedy for breach of an insurance contract prior to the statute's enactment. And that's something that this court has also recognized in Time Life versus Berger, where the court again stated, this court stated, prior to the enactment of section 624155, breach of contract damages were available. And my opponent wants to rely on the Chalfante reasonable expectation doctrine line of cases to say that that's really what we're trying to do, is to rectify and recover the reasonable expectations of the parties. But the reasonable expectation doctrine is not a damages doctrine. I believe, like Justice Muniz noted, it was really kind of a throwaway line tucked away in Chalfante. It wasn't part of this court's true holding in Chalfante, which was discussing whether the implied covenant of good faith and fair dealing exists in a first party policy. And our contract, count 1 here, is independent of the implied covenant of good faith and fair dealing, which means that regardless of whether that implied covenant exists, we're still entitled to have consequential damages as a remedy in a breach of contract case. The other thing I would note about Chalfante and the reasonable expectation doctrine, again, like I said, it's not a damages doctrine, but also the we're not talking about any sort of bad faith case here. My opponent wants to talk about how, if this court rules in it's my client's favor, that it's going to open up the floodgates somehow and get into these claim file materials in a breach of contract case. And that's not going to be the case. And the reason it's not going to be the case is because the standard that my clients would have to satisfy to recover consequential damages is focused on a set moment in time, which is when this policy is issued. And that's important because everything that comes subsequent to the issuance of that policy is irrelevant, meaning anything that may or may not happen during the handling of any sort of claim is irrelevant to determining what was contemplated when the policy was issued. And at bottom, the way that Citizens and any other insurance company can get around this exposure is to do what the rest of the contracting world in Florida does, and that's contract around it. Citizens has in its policy the leasehold interest form, and that policy excludes or precludes Citizens from having to pay for consequential damages. And Citizens, despite having that policy language available to it, opted not to use it in the property coverage form, despite knowing that cases like Johnson, Travelers versus Wells, and all the other cases that we've cited in our briefing that recognize that this damage is an available remedy, it didn't use it, which is proof that Citizens was willing to accept the exposure of consequential damages if it breached. Now,
Counsel, would you further explain for us why this claim, the claim that you're making, is not essentially a bad faith claim?
it's not a bad.
Well, I understand that's your position, but when I look at it and when I compare the kind of allegations you're making here and the kind of allegations that are made in bad faith claims, it sure looks like one to me. And so help me understand why it's not.
Certainly, Chief Justice. The starting point for that answer begins with this court's decision in Blanchard, where this court said a bad faith claim is grounded on the legal duty to act in good faith, which we know is under 624155, whereas a breach of contract claim is predicated on the failure to perform a contractual obligation. Here we have in count one, 3 express provisions of the policy that Citizens failed to perform. First, the policy requires that the parties go to appraisal in the amount of a dispute on the amount of loss. It's not permissive, it's mandatory. So Citizens has to go. Second, Citizens has to pay the appraisal award within 30 days. We allege it didn't. That's just a breach. Either it paid within the time frame that it obligated itself to do so, or it didn't. And third, Citizens failed to pay the undisputed sums that it agreed owed within 20 days. The latter 2 of our contract allegations are predicated on the loss settlement provision, which require payment, the act of performance, within a specified time frame. So those are the express obligations that Citizens, we allege, failed to perform, which is the contractual obligations that are independent from the duty to act in good faith under 624155, which now, when we go back to what I said in Blanchard, places us in the breach of contract context. And furthermore, Justice Kennedy, even Citizens told the trial court at the loss rent summary judgment hearing that count one was a pure breach of contract case. And that is a direct quote from record 4,807, lines 18 to 20, a pure breach of contract case. We had a separate count for the implied covenant of good faith and fair dealing, which we recognized after Chalfonte was no longer viable. So we're not pursuing that anymore. But we still have the count one breach of contract that we have predicated on these express provisions. Now, I know that Citizens wants to focus on the wherefore clause and how we say that our consequential damages are predicated on the failure to timely pay. And Justice Kennedy, to your question, furthermore, the reason why that allegation, failure to timely pay, is not a bad faith allegation in this case is because we have the loss settlement provisions of this policy that mandate an express time frame within which Citizens is to perform. So we're not concerned about, like we would be in a bad faith case, whether Citizens breached in an ugly manner or a negligent manner, whether it was willful and not performing or whether it was not performing in some malicious manner. Motive is irrelevant in the context of a breach case, and a motive is irrelevant here. A breach is just a breach. And that's all we're going to be proving to the jury. It's going to be 3 simple questions. Did Citizens breach the policy by failing to go to appraisal? Did Citizens breach the policy by not paying the appraisal award within 30 days? Did Citizens breach the loss settlement provision by not paying the undisputed sums it agreed it owed within 20 days? Those are the contractual obligations that Citizens obligated itself to perform. And if Citizens wants a better rule of damages than the rest of the contracting world, then when it breaches a policy, it should do so through its contract. But like the court in Thomas versus Western World said, absent an express sort of provision in the policy that limits the damages available in the event of a breach, the adhesive nature of the insurance policy precludes us from getting into doing that and engaging in the sort of post-loss rewriting of the policy that Citizens wants to do here. Because the plain language of this policy, undisputedly, does not limit any damages that Citizens has to pay if it breaches this policy. Which then, to go back to Citizens' argument about how, we need to look at the plain language of the policy and its express terms, the express terms don't limit what Citizens pays if it breaches, which again, I think the court's decision in Thomas versus Western World is important on that, because really what Citizens is asking this court to do is to create a special rule of damages for insurance companies that are different than the rest of the contracting world. Justice Lawson, I think you're on mute.
Thank you for recognizing that. Am I correct that the damages that you would be seeking under your breach of contract theory are different from the payout that you would be entitled to if the policy included lost rents? In other words, they're both lost rents, so it's easy to get confused. But if there was a lost rents clause in the insurance contract, your client would be entitled to lost rents from the date of loss, the date that the building was uninhabitable.
Correct. And we don't have that in this case, and we're not running our damages from the date of loss. Like I told the 5th District.
They would be run from the date of, well, based on the date of breach, but assuming, so you breached here. If you had not breached, we would have been able to have people into these apartments a year later. And so what we're asking for is the lost rents from that time period when we could have had them in and when we actually got folks in, rather than what you would have gotten under the policy, which is the entire period of lost rents. Is that correct?
100%, Justice Lawson. That is absolutely correct. And to further your question, we have already provided a cutoff date for the lost rent damage, which is in 2010, and that was flushed out in discovery at the trial court level. But Your Honor hit this right on the head with your question. We're not trying to say this is something that is covered because of Hurricane Francis. We're saying this is something that Citizens has to pay because it breached. And the starting point for that is the date of the breach. Now, the jury's going to have to determine what that is in this case because we have multiple alleged breaches. But that's something that juries do in breach of contract cases in the state of Florida on a regular basis. And there's going to be no harm or difficulty in doing that in this context. And so because of that, you know, the only other thing I would note is when I'm talking about how Citizens could have contracted around this damage, I want to be clear. We have cases like Johnson, Travelers versus Wells, Martin versus Monarch, TDS, all those cases predated the time when Citizens issued this policy to my client. So it knew this was an exposure out there for it in the event that it breached. And yet it still made the decision not to include language that other Florida courts have held was broad enough to preclude a carrier from having to pay consequential damages, such as lost rent, which is what the Bartram versus Landmark case held. There was a consequential loss exclusion that stated, or the court interpreted to hold, was broad enough to preclude a carrier from having to pay, in that case, lost rent. So there is more than enough language in the marketplace for Citizens to have utilized, and in fact, it did utilize in a different policy form at the time it issued this policy to my client, and yet it chose not to do so, which again, we submit as proof that Citizens was willing to accept this exposure. The only second line of cases my opponent talked about was McCullough. And he noted on page 455 of McCullough how this court had said, we were talking about damages contemplated in the policy. What's interesting about that is that part of McCullough cites the Penn site 1281 of Tallet, where the court says, we're talking about damages contemplated by the parties to the policy. And that's really the important phrase here, because that phrase mirrors the Florida standard jury instruction on consequential damages in a breach of contract case. And it's that jury instruction that this court has approved. So Tallet or McCullough, neither one preclude the recovery of this damage, because those decisions were talking about what remedies or interpreting 624-155. Which is not what we're talking about in this case. And if we were to read McCullough and Tallet the manner in which my opponent is asking this court to do, then we would essentially be reading out of section 624-155, subsection 8, which, as I've already noted to the court, has said we're not going to preempt any common law remedy. And it would also be conflicting with or receding from this court's prior decisions in for example, Time versus Berger, where this court has recognized that prior to this enactment of 624-155, breach of contract damages were already available. So with that then, the only other point I want to make to the court is these damages, these consequential damages, are not some sort of disguised bad faith damage. Like the court in Berger said, and as my opponent even noted here today, 624-155 provides more damages than were already available to policyholders in a breach of contract case. And my opponent gave I think the best example that I could give this court, punitive damages. We know that breach of contract does not allow any non-breaching party, policyholder or otherwise, to recover punitive damages. And yet that is an available remedy under the bad faith statute. Because
Counsel, I'm sorry to interrupt you. Do you agree with the counsel on the other side that the practical consequences of this case, regardless of how we rule, would be limited just to the citizens' context?
by and large, probably so. However, I am aware of some cases, and we've actually cited them in our briefs, where I think as late as 2018 in the Manor Court decision, there are policyholders out there that are seeking consequential damages from non-citizen insured policies in a first-party breach of insurance contract case. So it is not something that is solely limited to citizens. This is a remedy that policyholders are seeking from private insurance companies independent of 624155 and are doing so in a first-party breach case. And I think the Manor Court decision is also important because it is decided after Chalfante, which is further proof that this court's decision in Chalfante did not affect or impact the availability of this consequential damage remedy in a first-party breach case. Now, in the briefing, Citizens wants to distinguish cases like Manor Court, Trident Hospitality, or Martin versus Monarch on the grounds that they were decided at some pleading stage, whether it's a motion to strike or a motion to dismiss. And I would submit to the court that that distinction is non-dispositive and is one without a difference, because of the fact that if this remedy, as my opponent argues, was as a baseline rule not available, then the court would have struck those damages in those cases because they would be immaterial, or there would not be a cause of action for them. But the court didn't. And the reason is because, as we've stated, this is a contract claim. Consequential damages are a contract remedy. It's been recognized in Florida for at least 38 years in the insurance context, which is why we're asking this court to answer the certified question in the affirmative, affirm the 5th District, and hold that consequential damages are a permissible remedy in a first-party breach case. Thank you.
Thank you.
First, let me respond to some of those arguments. As to the Tallet case, which counsel alluded to and said that all it talks about is that they're allowed to recover damages contemplated by the parties to the policy, not contemplated in the policy. That's in a quote from one section of the case, but the case also says, and I'm going to quote, in the context of a first-party insurance claim, the contractual amount due to the insured is the amount owed pursuant to the express terms and conditions of the policy after all of the conditions precedent of the insurance policy in respect to payment are fulfilled. So that case from 2000 is crystal clear. Those are the damages you get at common law for breaches of an insurance policy. So their claim that, we don't address 624155 paren 8, which says that nothing in this statute precludes a common law cause of action, that just begs the question of whether there is a common law cause of action, which is exactly what we're here to determine. So subsection 8 is neither here nor there. It just offers no opinion in that regard. They cite Travelers versus Wells. That was a breach of contract to procure and issue a workers' compensation policy. And because the insurance company refused to issue the policy, they had to go out of business because they had no workers' comp insurance, and they sued on that basis. It was not a traditional breach of first-party insurance contract case. They cite Time Insurance versus Berger. That was a bad faith case under section 624155, which held what damages are available in those kinds of actions. He argues that in QBE versus Chalfant and in Denny, their statements were not part of the holding. Well, in Denny, it was an integral part of the holding as to how to interpret an ambiguous policy provision. That was precisely the issue presented in that case. And the court said, you don't go outside the policy. You don't look at the reasonable expectations. You stick to the language of the insurance policy. And if there's an ambiguity, you interpret it in favor of the insured. The counsel argued about how it's not going to affect discovery in a case. Well, let me explain what happened to you after happened to us, after we paid the appraisal award, which we paid in January of 2010, 36 days after the appraisal award. 6 months later, they filed a second amended complaint where they asserted all of the allegations we're arguing about now. That was not filed until after we paid the appraisal award. And then for the next 7 years, there was litigation on that amended complaint. And part of that litigation, if you look at the docket sheet and the record, is motions for protective order, because they were seeking to discover from us work product information and attorney-client privileged information. And we said that is not available to them, no matter the allegations that they are making. And the court granted those motions for protective order. My opponent talks about consequential loss and how we excluded consequential losses in other parts of the policy. They're confusing consequential loss, the term consequential loss from the peril, with consequential damages from the insurer's conduct. Those are two different things. Consequential loss is damage occurring, let's say, from a hurricane, but indirectly from a hurricane. In other words, the hurricane produces some damage that produces other indirect damages, and insurers can exclude those consequential losses. It's not about consequential damages as a result of the insurer's conduct. In fact, an insurer wouldn't be able to do that, because then they would be excluding themselves out of 624-155, which does allow consequential damages. So that comparison to consequential loss does not apply. They talk about the complaint alleging that we failed to meet the lost payment provisions. Well, if you read the complaint, there's nothing in the complaint that that talks about any specific lost payment provision. In the breach of contract count, they assert breaches of the policy in general terms. Paragraph 56, they claim, and that's in the breach of contract count, citizens has failed to fairly, honestly, or properly adjust the loss with its insured, thereby breaching the policy. Paragraph 63 in the second sentence, citizens' failure to proceed voluntarily to the contractual alternative dispute resolution process of appraisal constitute a wrongful denial of this claim and was in breach of the policy in Florida law. No lost payment provision. Citizens, and then 64, citizens' failure to timely and appropriately pay the amount of the appraisal award constituted a wrongful denial of the claim. And then 68C, they say, as a direct and foreseeable result to the plaintiff's property, plaintiff has and C suffered and will continue to suffer consequential damages due to the defendant's delay and failure to pay this claim. That's exactly what a claim under 624-155 1B1 alleges, which is the failure to settle, and that's the most commonly used provision, failure to settle when under all the circumstances they should have and could have done so. So they don't allege any particular policy provision, but if you look at page 45 of our appendix, which is the policy, that will give you the lost payment provision. And we're not obligated to pay on any claim until there's an agreement on the amount of the loss, number one, or 30 days after an appraisal award. And it's undisputed in this case that we paid 36 days after the appraisal award, so arguably 6 days late, and we paid prejudgment interest. We paid more than they were entitled to. There's no claim that prejudgment interest was inadequate. So for those reasons, we ask you to quash the decision of the DCA and answer the certified question in the negative. Thank you.
We thank you both for your arguments today. The court will now stand in recess for about 10 minutes before we take up our next case.